interesting insight on the flavors as to how the ISDS provisions are being interpreted. I think we can have perhaps 5 minutes for us to do some questionings. Are there any questions? Yes?
Well, my question is directed towards the last speaker, and it's in respect. I think I really have 2 questions, but perhaps they are related to each other. I must preface this by saying I'm not terribly familiar with the process, but it's a matter of general principle. The first one is in relation to the Salvos case, which we briefly talked about at lunch. Now, in the Salvos case, there was a party actually exhausted its remedies in the national courts here, and then found itself able to overreach all of this by initiating an investment treaty arbitration, which, as you say, the first tribunal didn't want to assume jurisdiction, but then it was annulled, as I understood it. But it begs the question: is how can you overreach private rights, which are negotiated between parties in some detail, and national legislation, which is completely overreached by these treaty tribunals, which are basically 3 people sitting and completely setting aside everything else that has happened before. Now, the second question, perhaps related, and again, I don't know the circumstances. In the first one, I have some knowledge of the circumstances because our firm was involved in that first private arbitration. In the second one, it's the Thai toll roads project. Now, it's I would have thought that a contract or there would have been a concession contract of some kind, where the risks would have been allocated between the parties, and things like sensitive issues like tolls, which affect the public, and where the government presumably has to retain some level of control over how much you can increase tolls, because they have to balance the public interest against the private investors' rights. All this would have been resolved. All this would have been covered in the concession agreements and the underlying and presumably the statutory framework prevalent in the country. Again, completely overridden by the treaty, the kind of investment treaty type of tribunals, which is able to award a huge sum in favor of the investor. Now, that seems to me to be fundamentally wrong, and I can quite understand why you have these demonstrations going on in London, because it seems to be it really strikes at completely overreaching some fundamental principles, and perhaps you could give us some enlighten me on some of those. Those two issues that I brought up.
Thank you very much. I mean, they're very interesting comments, and I'll take them in turn. The first question relates to essentially different causes of action. The claimant may have a cause of action under a contract for a violation of their contractual rights, but as a matter of international law, if they have treaty rights because they're a qualifying investor with a qualifying investment, then those are rights that derive from public international law, and the nature of those rights is different from the nature of their contractual rights. There are umbrella clause issues potentially which can complicate that a little bit, because an investor can try sometimes to elevate a contractual right to the treaty claim. But leaving that issue aside, which is a little bit more particular than I think what you're talking about, the short answer, I think, is that the basis for the claim is different. So an investor can bring a commercial arbitration to vindicate their contractual rights, but they can also bring an investment treaty arbitration to vindicate their public international law rights under the treaty. The second question really relates to a state's sovereign rights, I think, is what you were getting at. And I mean, from an investor's perspective, the bad news is that a state has a complete right under public international law to expropriate an investment. That's the case whether or not there's an investment treaty. from an investor's perspective, the good news is that if there's an investment treaty, then provided that it so provides, then the state has an obligation to pay prompt, adequate, and effective compensation or some similar standard of compensation. So a state always has a sovereign right to expropriate even, but the difference with an investment treaty and what a difference it can make is that the state, if it does do that, is then obliged to pay compensation, often market value compensation to the investor. So I don't know if that will necessarily satisfy, but that would be my answer to the questions.
Chester, you have anything to add? Or Harpreet?
I mean, I think Hussein's got that absolutely right. As for the first point, the two separate causes of actions is the critical issue. But in the second point, states have sovereign rights to do whatever they like on their territory, but they are limited in their action by international law. And if they expropriate privately held rights of a foreigner, there's an obligation to pay compensation. There's an obligation not to do that in a way which is discriminatory, and they can only do that in a way which is in support of a public purpose. But there's that obligation to compensate an investor, and that exists under customary international law and also under investment treaties, which gives the investor the right to assert that in their own name and vindicate that right and not have to rely on their own state of nationality to help them out by way of a diplomatic protection claim.
Thank you very much. Is there any other question? Yes?
It's directed to Harpreet. Right. There was a case in China called Jublin, and this case was arbitrated in ICC Shanghai, but eventually the Supreme People's Court put aside the ruling. They do not recognize ICC ruling. So from your presentation, there seems to be a few carve-outs on your presentation. Is there any other exceptions to the Supreme Court of China where people may bring their case for arbitration and then at the end of the day they said this is not recognized? So I just need to know whether there's any more exceptions, or do they still not recognize ICC?
The first has to do with the scope of arbitrability under investment agreements to which China is a party to, and the second would be about carve-outs. So on the first, having reviewed a number of the agreements China is a party to, I find that they do tend to try to request that the investor first go to its domestic courts, and in some instances only restricts the investor to its domestic courts depending on the subject matter of the claim. So in that as well, you already see an existing preference to leave it to the courts of China and not provide too much of an avenue for investors to go to investor-state arbitration. On the second, on carve-outs, and I think this also relates to some extent to the question just before this, in the agreements, in what I call the third generation agreements, these are these big mega regional agreements coming out, and they're also agreements which seem to carry over the NAFTA type model of a number of exceptions to their obligations. I don't think that, to my knowledge, that the arbitral rules fall anywhere within those exceptions. The exceptions always come down to the subject matter of the measure and the linkage between that and the state interests, and depending on whether or not the state parties have turned their mind to the scope of interest that they would like to keep out of arbitrators' hands, that really determines the extent and the specificity to which those exceptions have been laid out in the agreements. ASEAN-China, for example, I should say, the table I put up, it's not exhaustive. There are a number of other exceptions, I believe, relating to government procurement and services as well. So I hope that answers your question. Thank you.
We can take, I think, one more question. Yes.
Very good question. Beginnings we saw in the late 1950s through the 60s and 70s on the basis of model agreements, and they were model BITs that were prepared by bodies such as the OECD, put out a draft model investment treaty in the 1960s, and that was used as the basis for a lot of the European capital exporting states like the UK, Germany, France, Switzerland, used that as their template, if you like, to negotiate their investment treaties. And we've seen Germany has about 100 BITs, the UK has about 90, France has about 80, Switzerland has about 90. Most of these are based on this sort of 1960s model. Now, this was developed by the OECD, which is, you all know, is a capitalised, capitalist sort of capital exporting countries, industrialised countries, and the way that they're drafted is in this kind of bare bones way, where I set up some of the provisions earlier in my slides, which have been interpreted or can be interpreted in a fairly investor-friendly way, and they don't contain the kind of carve-out language that we saw that Harpreet had on some of her slides, and the definitions of what FET means and the definition of what is and what is not an expropriation. So out of the 3,000 or so BITs we have, the overwhelming majority are based on a type of template, and quite often of course these are all negotiated, as Hussein rightly made the point, they're all negotiated and there's subtle differences in all of them. But from my experience at the Foreign and Commonwealth Office, I spent a number of years negotiating these treaties, and not in my time, but my predecessors who were negotiating them in the 80s and 90s. Quite often the developing country who was at the other end of the negotiation, who was desperate, falling over themselves to get a BIT with the UK so they would attract UK foreign investment, would sign whatever the UK put before them. Sometimes even the UK would send, here's our model BIT, do you have any comment on that? The answer would come back, yes, we've signed it, here you go, and the UK negotiators would have to go back and say, oh, actually, there's some blank things in there that we need you to fill in. We need you to define what is your territory. We need you to define what is the relevant authority for X, Y, and Z. That's anecdotal, probably embellishment, but these things were negotiated with... to say that developing countries were equal negotiators is probably not right. And so we're now seeing a correction of all of this with the more filled-in, better definitions of what's an expropriation and what's not. This means all of those model BITs are changing, and states are constantly updating their investment treaty templates. Is there scope for developing a universal model investment treaty that all states would be happy to sign up to? I think maybe that's difficult because states have different interests. Capital exporting countries want strong protections for their investors. Capital importing development countries want to allow themselves a fair amount of policy space to adopt measures that they may need to adopt if they're going to further industrialise their economies, if they're going to be able to take measures to protect the public interest in whatever way. So I think it's a wonderful ambition if we could do that. We saw the OECD try and do this in the late 1990s with the multilateral agreement on investment. It failed. States cannot agree on a multilateral set of rules, even though they're quite happy to negotiate bilaterally. They are unable, or have until now at least, proved unable to agree on a multilateral set of rules, in contrast to the way that we've looked at international trade being regulated under the WTO, where there's the GATT and the GATS and all of the covered agreements under the WTO, where states are far more able to agree on what the rules are. But I think the short answer is I would love to see that happen, but
yes, Harpreet and Hussein, you'd like to comment further?
I'm just going to add on briefly, and I'm going to be so bold as to differ from Chester a little bit. I think there is potential for a de facto model of the ISDS provision in particular to come into existence eventually, because if you recall the slide where I began to show how these agreements are encompassing more and more countries, the models for those agreements as well, I find that there's a convergence of treaty models on the ISDS provision in particular. So if you look at, say, the EU-Singapore agreement and the ISDS provision and the ASEAN-India ISDS provision, for example, very similar but very different countries. So perhaps, and it may not be universal at the end of the day, I do think that there is potential for a model of the provision to come into existence.
Hussein, you have the last word.
I hate to be hate to be Solomonic. I mean, I agree that there is some convergence, but I have to say I also agree with Chester's point. Having advised one government in particular that's capital importing as well as capital exporting at one stage, and I won't say which state they are, but at one stage they had 3 unofficial model investment treaties. So if one state can't agree on one treaty, it's probably going to be hard to get every other state to do that. And I think states in some ways are a bit like lawyers. You put 100 in a room and you'll have 101 different opinions sometimes. So it can be difficult.
Well, thank you very much, and to our 3 speakers. They've given us an excellent presentation. Can you join me to give them a round of applause, please? Thank you. Thank you.